A lot of new documents have been filed in the Justin Baldoni versus Blake Lively case since our last update. So today I'm taking a break from the deep dive into Justin's amended complaint to catch up on these other documents. A few of them are sealed, so we won't have access to them, and a few of them are just administrative things. So we're going to concentrate on some of the more important ones. And there's a lot to cover. So let's get started. This is Legal Updates with Cassidy. Justin Baldoni versus Blake Lively. All the latest filings. February 17th. Welcome. After I'd already recorded this episode, there was also a response filed by Blake's attorneys responding to Team Justin's filing, calling the subpoenas overbroad. They clarified what was subpoenaed, along with some sass. This episode is already pretty long, so I'm going to save that because I expect the judge to rule on this probably Monday, and so I'll go over those two documents together. So document 65 is Blake's request for extension of time. It points out that the original deadline was February the 14th, and she requests it to be amended to March the 5th. She also asks for clarification on the deadline for motion to dismiss. She asks to clarify if it's March 20th, and if it's not, could it possibly be moved to March the 20th? They say that they have discussed this with opposing counsel, but they have not heard a reply from them yet. And they also mention that the Wayfair parties have asked for and received extensions. And as is common, when requesting an extension, it has the detailed reasons for why this is needed. They say that the majority of the Wayfair defendants have not submitted responsive pleadings. They also say it will give them time to address the extensive new facts and claims in the litigation. Also, as expected, and the reason I began with Justin's amended complaint is because I knew once these cases were consolidated, and as they began collecting discovery, that the others would follow suit with an amended complaint as well. And once they file amended complaints, it makes the previous versions moot. So with Justin's being the only one that had been amended already, it had the longest shelf life. So as expected, Blake will be filing an amended complaint based on these new accusations and new information. So she points that out as another reason why she needs more time, that there were extensive new facts and new claims, and her amended complaint will therefore add additional parties and claims, and it mentions one of those being Jed Wallace. He will be a pretty big topic today because, as it goes on, he filed a 10-page complaint in the federal district court in Texas. The issues in his complaint, as they say, substantially overlap with the issues in this litigation, but they call his filing anticipatory and meritless. And if that's not enough, in the next sentence they say that the additional time requested will allow Ms. Lively to address properly the procedural issues arising from the unmeritorious lawsuit as well. So meritless and unmeritorious. They spend another paragraph repeating themselves, and then mention that the schedules are a little different because there were different suits filed. Those had dates, and then they were all clumped together in one lawsuit. And this makes sense that the deadlines of the different lawsuits would have to alter some now that they all belong to the same suit. This way they'll be in alignment. In addition to calling Jed Wallace's complaint meritless, they also in the footnote say that it presents serious issues with respect to jurisdiction, venue, and claims, and they call the motivation into question. That's going to come up in a moment as well, so keep that in mind. And so they repeat once again that they're asking for an extension of time till March the 5th, and the deadline to file any motion to dismiss, March 20th. And then we move on to the response from the Wayfair group. And when I say the Wayfair group, it's just a way to shorten Wayfair, Justin Baldoni, Jamie Heath, Steve Sarowitz, and then the PR people Melissa Nathan and Jennifer Abel. But rather than say all of those names, when I say Wayfair group, that's who I'm referring to. And if you haven't noticed that already, this is the way these work. One side files a motion requesting something. The other side has a specific amount of time to give a response so that they can give their opinion of the situation. Sometimes these are in opposition to each other, and other times they're fine with it. Sometimes there will be a little back and forth, a reply to a reply. Then the judge will take both sides' opinions and rule on it, and then we get the order. So this is the response to that request for the extension of time. And they start off a little bit spicy. They say, notwithstanding the Lively party's inexplicable refusal to consent to a similar extension requested by the Wayfair parties in the throes of the Los Angeles wildfires, the Wayfair parties have no objection to the extension sought by the Lively parties. So rather than just say, we have no objection, they get that little dig in there. We're okay with it even though you guys inexplicably refused to consent to an extension when we were burning. And then they ask in turn that the court also extend their deadline to respond to April the 16th. And then it digs in. I told you we'd hear more about Jed Wallace. They say, unfortunately, the Lively party's letter goes further than a simple request for an extension of time, leveling unnecessary and baseless attacks on non-party Jed Wallace and the litigation pending against Miss Lively in the United States District Court for the Western District of Texas. What the Lively parties conspicuously failed to mention is that the now pending litigation in Texas was precipitated by Miss Lively, who initiated legal action against Mr. Wallace in Texas State Court on January 21st, 2025, approximately 2 weeks before he filed his federal lawsuit in response. So he's saying that that was unnecessary to attack this because you brought this guy into it. And remember that little footnote that talked about jurisdiction and venue? Here's why that was important. He says while the Lively parties now claim that Mr. Wallace's Texas action suffers from serious issues with respect to jurisdiction, venue, and claims, in Miss Lively's verified petition seeking a pre-suit deposition of Mr. Wallace, Miss Lively acknowledges that jurisdiction in Texas is proper given Mr. Wallace's domicile. And they attach a copy of that. And we're going to go through that today. Because in addition to this issue about jurisdiction, and he's absolutely right here, and you'll see it for yourself, but there's a statement that's very alarming in that document. And you might wonder why he's concerning himself with this lawsuit that he really has nothing to do with. Because he notes here, there's a sentence in Blake's document that really doesn't look good for her, and it could affect the Wayfair parties as well. He says, notably in her pleading, Miss Lively concedes that she lacks sufficient facts to state a claim against Mr. Wallace, hence the need for pre-suit discovery. But you'll see it goes a little deeper than that, and I'm wondering why he didn't mention it. Then he goes on to say that Mr. Wallace is represented by separate counsel. He's not a party in this case before this court, but they strenuously object to Blake's assertion that his lawsuit is meritless or unmeritorious. And they repeat that they do not oppose this extension, but they want their deadline extended as well. So now to this document that he attached. This was filed by Blake, and it was filed in Texas. It's not a lawsuit. What it is a petition to depose Jed Wallace. And I have to say, like we've been discussing in the coverage of Justin's amended complaint, and if you haven't watched that, go to the playlist version of my channel and you'll see parts 1 to 3 there where we discuss in depth, page by page, of Justin's amended complaint. There's also the first update on filings. But as was mostly discussed in part 3, is the weird way that Blake and Ryan chose to handle this situation. As I said, they're not new to the business. They're not young, inexperienced people. If you're facing sexual harassment in 2025, where you have a union behind you to support you, where you have a legal team to support you, all of this could have been avoided if they had made the proper use of all of those tools at their disposal. When you face something serious like sexual harassment or sexual inappropriateness, that's what things like this union are in place for. That's what things like your lawyers are in place for. If these events truly happened, the first step that should have been taken was contacting the union or the attorneys. Had they done the proper steps to take care of these alleged offenses, none of this would be happening right now. But if we say this happened, why didn't they take the appropriate steps instead of 1, putting out the 17-point agreement and then hijacking the movie? Everyone in this lawsuit is in this lawsuit because Blake, instead of reporting it and handling it appropriately, used it as blackmail to extort her position as beyond the actress she was hired to be. That ultimately led to her making her own edit and blocking Justin from everything. It led to her being able to go off and tell everyone she directed, she produced, she got her PGA mark, that she wrote, made the claim that Ryan wrote, got her own music, and wiped Justin completely out of all the marketing. Ryan's response was to scream at him, tried to force him to admit the allegations, which Justin would not do, and ultimately alter his own movie, create a whole new character to mock it. If you're a husband, if you think your wife is traumatized by her treatment at work, and your response is to go make a film about it and make tasteless jokes about it, to you yourself portray the character that traumatized your wife and say things that you and she claim were traumatic to her, and you do it all in joking, and then have her come as a character and kill the man, that's your response? Rather than go to your union, go to your attorneys, go address this? If these allegations truly happened, that was not the way to handle it. To make light of it, to joke about it, to act it out, so she has to see it again, something that supposedly bothered her so much, that is not how you react to your wife's trauma. And now here we are. But because of these reactions, and because of the evidence that's been shown so far, that's why so many of us are having trouble believing that they happened. And I do want to say, there's a group of people in this Believe Women campaign that are calling any of us that have any doubts on this misogynists, simply because we don't just go, oh, a woman said it, it must be true. This is the first time I personally have doubted this kind of allegation in my life. Other than this case, I have always believed the woman in cases like this. But this evidence is so sketchy. The reaction of the woman and the woman's husband are so sketchy. How dare you call us misogynists? Because this evidence just cannot hold water. There was a case in the news. A woman saw a man with a pickup truck in a parking lot, and in her words, he looked creepy. He did nothing to her. She had a cut above her eye from a previous incident, and she reports to the police that this man attacked her and kidnapped her. The police believed her. The man spent time in jail, but as they continued the investigations, her story wasn't adding up. She couldn't keep it straight. The evidence wasn't adding up until finally she admitted that she lied about it. This man did nothing to her. He didn't speak a word to her. She saw him in a parking lot, thought he looked creepy, and made up that whole story. You can't say something like, believe women, and that if a woman has a story that doesn't add up and someone doesn't believe it, that they're misogynists because they didn't believe a woman. Women lie too. You have to follow the evidence. When a person, man or woman, keeps getting caught in lies, they're no longer believable. And it's outrageous to expect people to believe her simply because she's a woman. Many of us are angry about this because of what it's going to do to so many women from here on out. Every woman that gets caught lying in these kinds of accusations make the actual victims not be believed. That's why we're angry. We're not misogynists. We believe in truth, and we want the future of women who are real victims. We want them to be believed. And these kinds of cases where women lie will do so much harm. We can't even tally how much harm it's going to bring. But it's not surprising, given the fact of Blake's response to the Harvey Weinstein accusations. I believed every one of those women. Did Blake? While those of us being called misogynists for not blindly believing Blake without seeing actual evidence of this, here's what she had to say about these more than 80 women who accused him of sexual harassment. She told The Hollywood Reporter in October of 2017, "That was never my experience with Harvey in any way whatsoever." Why say that? Doesn't that sound supportive of Harvey? Defensive? She goes on, "I think that if people heard these stories, they're not stories. Stories are often fiction. I do believe in humanity enough to think that this wouldn't have just continued. I never heard any stories like this. I never heard anything specific, but it's devastating to hear." She also starred in one of Woody Allen's movies, someone that a lot of people in Hollywood turned their backs on because of allegations against him. And Blake's publicist, Leslie Sloan, was also Harvey's publicist. In fact, in 2014, her firm that we're seeing in these lawsuits, Vision PR, guess who funded it? Harvey Weinstein. So how much concern does Blake have for other women that we should all just blindly believe her and support her? Now, there's some big things at play in this document. In addition to the regular PR people, Once the situation with accusations made by Blake came to light, Justin and Jamie and other members of Wayfair were rightly afraid by what she might do. Anyone in their shoes would have been. They'd already given in to everything. She'd made threats. She had extorted, basically blackmailed. And then when they wouldn't give the letter for her to get her PGA mark, she said all goodwill between us is gone. Apparently, all goodwill was already gone, so this had a stronger sense of threat. So in addition to their PR, they also hired a crisis management group. It takes a while for the law to catch up with changes in the world. Defamation used to simply be printed page. Now with social media, ever-growing amounts of people reporting on stories, it's out there on YouTube, it's out there on TikTok, it's out there on Instagram, it's out there on X. There's so many mediums for it now, and laws have not yet been made to cover all of these things. So these methods don't necessarily have laws against them yet. So here's where it gets difficult to label this stuff directly as defamation and walk away with the conviction. Now, what they accuse Jed Wallace of doing is executing confidential and untraceable campaigns across social media, specifically to shape public perception of his clients and their adversaries, and to perpetuate those perceptions. And now we get to where this starts to really go off the rails, though, in my opinion. Part B, the film and negative sentiment against Miss Lively. They say Miss Lively and others on the set were subjected to a pattern of unprofessional and sexually harassing behavior by Justin and Jamie. As in Part 3, the actress playing young Lily Bloom sent Justin texts after her filming going on and on about the comfortable and safe atmosphere that she was able to work in with him, thanking him for being such a wonderful director. She unfollowed him on social media long after that, after she started spending time with Blake promoting the movie, where Blake would be there with her arms wrapped around her, holding her hand, lending her her expensive jewelry. Other cast has allegedly gone on to be helped by Ryan to be placed in more movies. So it seems lots of favors, lots of love bombing, was able to alter a documented opinion of Justin. The next one, though numerous human resources complaints were raised regarding Mr. Baldoni and Mr. Heath's behavior, then it mentions that 17-point document that Blake made them sign in order for her to return to set. And all of this hinges on one little point of the 17 points that has a provision prohibiting retaliation of any kind. And they keep mentioning this retaliation contract. So we're going to look at that. It's point 10 of the 17 points. And it says, there shall be no retaliation of any kind against artist, being Blake, for raising concerns about the conduct described in this letter or for these requirements. So this is specific retaliation for raising concerns. Keep that in mind. Any changes in attitude, sarcasm, marginalization, or other negative behavior, either on set or otherwise, including during publicity and promotional work, as a result of these requests is retaliatory and unacceptable and will be met with immediate action. So there's some qualifiers in this statement. This isn't this broad blank statement that they're trying to make it out to be. For one, the actions cannot be as a result of her raising concerns about the conduct. That's very specific. So in addition to finding that there's been a smear campaign, they have to prove that the smear campaign was put in place to retaliate for Blake raising concerns about this conduct. Is that what this PR campaign was for? Was it because Blake rose concerns about this? Or was it something else? Also, further qualifying, changes in attitude, sarcasm, marginalization, or other negative behavior either on set or otherwise. It talks about during publicity and promotional work. This is about treatment of her. Treating her with an attitude, treating her with sarcasm, marginalizing her, or treating her in a way that she's not important. So the specifics of this was, in response to her making these complaints, that because of these complaints, he can't now treat her nasty at work. They were supposed to do publicity together, and later she just cut him out completely, wouldn't allow him anywhere near it. But had they been doing that together, he would not have been allowed to retaliate to her saying these things by treating her badly. But they're treating this statement, as I said, like it's some broad, all-encompassing, as if it covers this situation. I think it's a stretch to say that this little paragraph covers the situation we're in now. This does not strip him of the right to defend himself, which is what he was doing. That's why you have PR. That's why you have crisis management, to defend you in times of crisis, like having accusations like this leveled at you. And then it comes to the question, did these PR people and this crisis management person, did they retaliate about these allegations? Or were they just there to help Justin keep his reputation? Because what happened? Justin was being excluded from everything. That was making people ask questions. Are we going to pretend that this little paragraph with its qualifiers means that he can't do anything to protect his reputation? That he has to, for the rest of his life, just stand back and let her do or say whatever she wants to about him? I don't think so. Nothing happened on the set, which is what she asked for. Nothing happened during promotion or publicity because they weren't even together for any of that. He did not break this contract. This contract simply doesn't cover everything for eternity. And they go on calling this a retaliation campaign, and they use some of the communication between the PR people and the crisis management guy that 99% of Justin's not even a part of the conversation. And they go on to describe it as a weaponized digital army around the country to create, seed, manipulate, and advance disparaging conduct. And 14 says that they fed pieces of manufactured content to unwitting reporters, making the content go viral in order to influence public opinion. What manufactured content are they talking about? Have we seen any manufactured content whatsoever out there? Because what I have seen is people criticizing the clothes, the wardrobe that she picked. It's hideous. Even Sony didn't like it. That's in the evidence. Paparazzi saw the filming in the open streets and took pictures of it, and it started to be criticized because it's hideous. And it got back to Sony, and Sony's like, what's going on? And Justin had to go talk to her about it. Those clothes are bad. What else was happening? She starts marketing the movie shortly before the premiere, and her promotion was awful.
Yeah.
What would be a good addition to the human body?
I would like another arm. If I had 3 hands working the keyboard, wow.
Is this like an extra thing that's already a part of our body?
No,
or is this like you can make up
like a cookie?
Wait.
And actually, probably it would be cool to have working wings.
Yeah, for sure. Or a cookie.
Or a cookie. Those are right. Where would the cookie go? Where? What kind of cookie? Like, what if you a vase cookie?
I don't know. Just like one here, you'd be like. You guys.
She had these skits with cooking, doing recipes, or drawing flowers and trying to name the flower. Even her co-star looked miserable sitting next to her doing this stuff. It wasn't entertaining. Anybody who read the book wasn't looking for that kind of stuff. And then I showed a clip from the one Ryan made that was so bizarre. The marketing was truly and honestly bad. People organically didn't like this stuff. There's nothing manufactured in here. Do you know how many people read that book? They were waiting for that story to be told, and then they start seeing this stuff? Of course they voiced it. We're in 2025. People talk about everything they don't like in this world. People organically didn't like this stuff. People also felt that she used this as an opportunity to promote 2 of her businesses, one of them being booze. People didn't think that was a good idea because alcohol a lot of times goes hand in hand with abuse. I have no objections to alcohol, but I find promoting your alcohol business with this movie to be very distasteful. She timed the release of her hair care line to come out at the same time. People found it distasteful. The stuff she said during interviews.
People who see this movie, who relate to the topics of this movie on a deeply personal level, they're really going to want to talk to you. This movie is going to affect people, and they're going to want to tell you about their life. So if someone understands the themes of this movie, comes across you in public, and they want to really talk to you, what's the best way for them to be able to talk to you about this? How would you recommend they go about it?
Like asking for like my address or my phone number or like my location share. Or I could just location share you, and then we could
It was terrible. People found her distasteful. She had picture after picture of herself posing in flowered clothes, saying nothing about the movie, but a long list of what she was wearing, all expensive, and all with the hashtag of the movie. These are the things people didn't like. These are the things people started criticizing her for. This was organic dislike. Nothing in this was manufactured. And in the communication between the public relations people, they're talking about this. They didn't even have to do anything. This just started happening. And once you start getting talked about and you're trending, other stuff starts being looked into and brought up. You hear she did bad in an interview? You Google bad Blake Lively interview? Guess what? There's a whole lot more than one. There's a whole lot more than just about this movie. There's years worth of those. From way back when she was on Gossip Girl, making fun of Leighton Meester for having been born in prison. Cruel stuff. A woman congratulates her on her baby bump. She turns around and snaps at her. Congratulations on your little bump. Not only was the woman not pregnant, but she later disclosed that she's infertile and that it's devastating to her.
Well, congrats on your little bump.
Congrats on your little bump.
What about my bump?
And for a woman who's so easily offended about what others might say about her body, listen to the next line.
You've got two nice ones.
And they are kind of bumps, aren't they?
No, not bumps. The lovely lady lumps. Check it out.
Thank you. Thank you.
Imagine that. And then what does Blake do? Disrespects her for the entire interview. Turns and engages only to her co-star, and they just go off on these ridiculous spiels of nonsense and leave the woman sitting there ignored, not even looking at her. It was a time period piece, so the clothes, of course, were from that specific time period. People talk about wardrobe. There's awards given for it. It was a logical question to ask. How do you feel wearing these clothes? Blake turns it around on her like she's being sexist.
It was so, visually amazing.
Yeah, it's gorgeous.
Did you guys love wearing those kind of clothes that you...
Yeah.
Yeah.
And, working in
Everyone
digital...
wants to talk about the clothes, but I wonder if they would ask the men about the clothes.
I would.
I love Jessie.
Oh, does anybody ask the men about the clothes? And then again, her and her co-star go off talking about the clothes and ignoring her, not even looking at her, trying to make her feel bad. None of that stuff is manufactured. And I'm telling you, it's a long list of videos like this. There's articles talking about a former actor on Gossip Girls that she admits and brags about having turned the entire cast against him when he came because she didn't like him. That's not manufactured content. These are all things that she has said publicly, that once people started to criticize, it snowballed from there. You can't blame that on anyone but yourself when you've done and said these things in public. And what kind of smear campaign is that anyway? Her clothes are ugly. Her marketing's awful. Her interviews are tone deaf. That's a smear campaign? That's defamation? What has she been able to point to that's been said about her that isn't something she herself did? How are you going to sue these people because you interviewed badly and you marketed badly, and then she's going to file motions to dismiss against the other side? The more this comes out, the less I feel like she has a case at all. Unless she can find some manufactured content that was lying and slanderous and wasn't her own behavior in public, what claim does she even have against these people? Are people telling lies about her? Or are they talking about her own actions and her own words? And the next line's just so ridiculous that they're saying that this manufactured content went out there to influence public opinion to safeguard against the risk of Miss Lively ever revealing the truth about Mr. Baldoni. How does that work exactly? So Justin and these PR people sat down and said, hey, if we circulate that her clothes are ugly and that she interviews badly, then she'll never say these accusations. Does that make sense? Is that the slightest bit logical to make this statement? I want to get out my gavel and say case dismissed. They go on to say that this team created, planted, amplified, and boosted content designed to eviscerate her credibility. Where's this content? I want to know where this created content is. Designed to eviscerate her credibility. And these PR people were there to help him defend himself from something she called crumbs. That's dropping just enough information out there to get people to question. Taking him off all the marketing. Not allowing him in any of the promotion stuff. Not allowing him at the premiere along with the rest of the cast. She was the one creating content by these actions. Everyone knows the director should have been there with everybody else. So when he's not there, a situation she created, that's going to bring up talk. Then all of a sudden, little bits of gossip started coming out about the cast being uncomfortable around him. Who put that out there? That at this point is hearsay. It's not been proven. That's not the kind of things that were being said about her. Completely different. He has a right to defend himself. So you can't 100% say why these PR people were hired. They're saying it was retaliation, but he was being accused of stuff. He was being excluded in a way that would make people start talking. Couldn't that be a reason why he hired these people? To help him out? He didn't know what to do. Can she say for a fact they were hired to retaliate against her? Because where's the retaliation that came from them? Where's this created content? They say that Mr. Wallace assisted them in their unlawful retaliatory social combat. Show me the laws. When you say something's unlawful in a legal document, you're supposed to cite the legal cases that declare it so. Most of these documents don't have that stuff. These are the most informal legal documents I've ever seen in my life. You should see the documents I normally cover. There are more cited cases to support their theories than you can find time to read. These have none. And then we get to this. In 16, they repeat that in the lead up to the premiere and the weeks that followed, that this social manipulation campaign was in force to undermine her credibility and retaliate. There was nothing undermining her credibility, and you can't even prove that they did this, let alone that it was for retaliation. They talk about more communication between these PR people and their comments about the social media campaign and how it was going. And I won't say it's okay if people are out there slandering, and it's probably time that laws are put in place to protect people from over-the-top PR, things that actually hurt others. And the example they give in 21, a post they say that they wanted to amplify or boost on social media. What was it? Was it some shocking expose on Blake? Was it some kind of leaked secrets? Something terrible? It was a post of Justin and Blake appearing to laugh together. People were starting to question what was going on between the cast and Justin. Couldn't it simply be they were trying to protect him from that gossip getting out of control by showing pictures where they were legitimately laughing together? I'm sorry, but there's not a court on this earth that's going to say that's defamation. It's a picture of them laughing. It's not undercover video of her committing a crime or manufactured stories of something she did. And then they mention the attorney, Brian Friedman, that he's brought on to defend what they're now calling the retaliation defendants. And now they call him a central figure in their active media campaign because he's come out and released some things to the public once her accusations became known. He's not wrong to do that. He can do that. Defense attorneys do press conferences all the time. They make statements to newspapers and news stations declaring their client's innocence. He released public files on a website. The same files that I had already purchased. The same files that other people have purchased and then shared. These are not hard documents to find. And he was criticized for that. The kinds of things that attorneys of this magnitude are accusing them of, I feel like these attorneys should know better. Is this a case of Blake and Ryan bullying their attorneys and making them do things they don't want to do too? 29, they say there's a close personal relationship between Mr. Friedman and Mr. Wallace, and that someone said they're very close. Is that a crime? It happens all the time that people who happen to be close to an attorney hire that person to represent them. That's a very, very normal thing to do. Why is this in a legal document? The attorney's close with this guy? So what? A whole paragraph about the attorney being close to Mr. Wallace. But they say that even though Mr. Wallace is not a named defendant, that they want to depose him to investigate a potential claim against him. And you can do that. That's allowed. But they're saying that despite acknowledging that he did take part in this social media campaign, that now he's saying that no digital manipulation campaign was carried out. And so that's why they think a deposition would serve the interests of justice. And that's perfectly reasonable. And now remember, this document was filed in Texas, and this document says this court, talking about the Texas court, has personal jurisdiction over Mr. Wallace because he's domiciled in Texas. He lives in Texas, in Hays County. Now, in that latest filing, they say there's big trouble with jurisdiction and venue. But this is their document that they wrote that says that this court has personal jurisdiction over him because he lives in Texas. And it goes on. This court has jurisdiction over the matter because a substantial part of the events took place in Hays County, in Texas. Point 36, venue is proper in Hays County because a substantial part of the underlying events that would give rise to the claims being investigated occurred in Hays County. Okay, you've already made it clear to the court that this is the proper venue. Why are you fighting it now? And then it goes on to talk about what kinds of things that they want to depose him about. Did he know about this contractual rider that prevented any retaliation of any kind? Like I said, that rider's very limited. I don't believe it covers this. You know, the judge will get to decide that, or a jury. And then about these accusations of the communication between him and the other PR about shifting the narrative. And then they do a lot of repeating about the scope and extent in these communications between them, and again about whether or not he knew about this retaliation thing. And then, as always, when you're making a request of the court to do some kind of action, you justify that action. And so points 43 to 50 cover that, the ways in which it would benefit the case. And now we come to the sentence that I said was very troubling. It's in point 48. They're talking about how this critical evidence about the specifics of his conduct on behalf of Justin and Heath, the coordination with these other PR companies, that this information is not otherwise available to them, which is a valid reason for taking a deposition. But this sentence, without this information, petitioner may be unable to pursue all claims against all liable individuals and companies. You're supposed to have everything you need to pursue a claim when you bring about the lawsuit. This sentence says, if we don't get this deposition, we have nothing to pursue these claims against the other people. Now, it's one thing to say we need to depose him to find out if we should add him to the lawsuit or not. But if you need his deposition, if without his deposition, you can't pursue the claims you've already filed lawsuits for, that sounds crazy. When you bring about the lawsuit, you should already have substantial evidence to prove your case. And then you get the details from the depositions. You don't file a bunch of lawsuits, and that the only way you can win those lawsuits is by deposing someone from another lawsuit that you may or may not be able to add because it depends on what he says in his deposition. This was really a poor choice of words for this sentence. And so I really think everything we've just seen in this document is why the Wayfair Group's attorney brought this to the attention of the judge. Because they can get a lot of good things from this one document to support their case, even using some of it to write a motion to dismiss. One thing's for sure, that amended complaint coming up from Blake really needs to have a lot better stuff in it than what we've seen so far. So let's take a look now at Wallace's lawsuit. When you get to the border of Texas, you're greeted with, "Don't mess with Texas." And I guess nobody told that to Blake. Because after she filed this document to depose Jed Wallace, he came back with his own lawsuit. They also say everything's bigger in Texas. And if you look at this font, I believe it. This is one large print legal document. He's asking for declaratory judgment and defamation. He introduces his company, Street Relations, telling us that it's a crisis mitigation firm to navigate real-life human crisis, threats, trauma, and mental health concerns. And it helps people when they've been unjustly attacked, extorted, doxxed, swatted, scammed, or need help navigating through the most frightening situations. Justin was indeed in a frightening situation. I think we can all agree on that. Under factual background, he mentions Blake's complaint, not the lawsuit, but the one that she filed with the Civil Rights Department. And in that document, she alleged that Wallace engaged in a variety of conduct in violation of the California Government Code, Section 12940. And you can see he is listed as a co-respondent in this complaint. This document lists 10 complaints for damages: sexual harassment, retaliation, failure to investigate, prevent, and/or remedy harassment, retaliation, an additional form of retaliation, aiding and abetting harassment and retaliation, breach of contract, intentional infliction of emotional distress, negligence, false light invasion of privacy, and interference with prospective economic advantage. Point 8, he accuses Blake of distributing this complaint to different and various media entities for out-of-court republication, and that because of the allegations, that it made headlines around the world. We first heard about this in the New York Times, but he also mentions Elle magazine, which linked to this document, as did many other media, he says. And then he points out that it followed up with an actual lawsuit on December 31st, 2024. And he says although he and his company were not named as formal defendants in the actual lawsuit, but that they were widely reported to be because the information of the complaint had already been leaked and he was a co-respondent on that. He says Blake later admitted that she knew of no facts to support the allegations against him or his company, but he says she knew the opposite. She knew that he had nothing to do with sexual harassment, retaliation, failure to investigate, or aiding and abetting harassment or retaliation. He said he couldn't have breached a contract because he had no contract with her, and that he was not involved in any of the events depicted. He then mentions that she filed this verified petition for Rule 202 deposition that we just covered on January 21st, and that this alleged that he was a subcontractor to the TAG PR group, hired to assist them in their unlawful retaliatory social combat campaign against her, and that in this petition, that Blake concedes that she has no facts supporting the allegations that she made against him or his company, and that she is seeking to investigate the scope of his conduct. He then states that she non-suited her 202 petition today. He calls this petition a transparent attempt to chill plaintiffs' free speech rights, and that it would have been fodder for a motion to dismiss under the Texas Citizenship Participation Act. He says that the statements of fact, actual or implied, are false, defamatory, made with either negligence or actual malice, and have caused millions of dollars in reputational harm, including both general and special damages. He says the actual damages and real and projected loss of business exceed the amount of $1 million. And we'll talk about that more in a moment. But here we come to the jurisdiction and venue. As I said in her document, when it comes to jurisdiction and venue, they often cite rules, laws, or other cases in their favor to show why their jurisdiction is the proper jurisdiction. So that's what we see happening here. And why is this such a debated and heated topic? Sometimes it's a matter of it being in federal court or state court, and other times it's location. These are both federal courts, but this one is Texas, the other New York. If he can't get this in Texas, that means he will have to travel to New York for the duration of this trial. It incurs expenses, and it raises a big problem with your attorney. There are so many different types of courts in the states. We typically just deal with state court versus federal court. There's also state Supreme Courts and the U.S. Supreme Court. There's tax courts, many different courts. And if you're going to court in state court, it requires that you have an attorney who has passed that particular state's bar. If an attorney wants to practice in more than one state, they usually have to pass the bar in the second state as well as their original state. And that's because each state has their own set of laws that differ from state to state. So in order to be able to properly represent your client, you must be familiar with that particular state's laws. So you would think that with federal court, since all federal courts are under the same rules and codes, that it would be easy for any attorney to serve in any federal court. But that's not so. The country's divided up into districts when it comes to federal court. So in order to be able to represent someone in a particular federal court, the attorney must be from that district. Now, is it possible to be from a different district and still represent a client? That depends on what district you're talking about. Some districts have reciprocity, and it's a pretty easy thing to do. The rest of the states have different levels or none at all, meaning that you can, but you have to apply, or that you also have to partner with an attorney that is in that district. So that's why you'll notice that a lot of the attorneys that are representing different clients in this case filed what's called a motion to appear pro hoc vice. As all legal terms, this is Latin, and it means for this occasion only. So we've seen quite a few attorneys file these motions. They have to get approval from the court to be able to represent a client here because they're not from that district. So, in this case, we're talking about Texas, which is going to be a different district than New York. Naturally, Mr. Wallace would prefer to have it in Texas, where he can be represented by attorneys he's familiar with. If he has to go to New York, he has to have an attorney that can file this pro hoc vice, travel to New York to represent him, or he would have to find attorneys he doesn't know in New York, or at least in that district. It will be the same for Blake. Team Blake didn't mind filing this petition to get this deposition in Texas, but now that it's going to become a lawsuit, they're saying, wait a minute, that's not the proper jurisdiction. Why? Because they don't want to have to go to Texas and deal with what they have to deal with to represent her there. And that's why they're both fighting for proper jurisdiction in this case. In this argument, at least, he really has so much on his side. Because Blake filed this in Texas. And in that filing, as we saw, she said that this court is the proper jurisdiction because that's where he lives and that's where these alleged acts took place in Hays County, Texas. So she's already put that out there. And he ends with a note that's also very true. The defamation plaintiff is accorded great deference in his choice of forum, especially when it is his home venue where the defamation is most keenly felt. Now, I mentioned some other defamation lawsuits that I'm currently covering, one of those being Austin Stanley versus Fitz News. There was a first-time ruling for the state of South Carolina because earlier laws were all set for printed page. So this was the first one that was about internet publication that was decided in this particular court. And he ruled that publication of defamation is where it is most keenly felt, just as this says. And where is that felt? It's felt where people actually know you, which would obviously be your hometown or your place of business. So this is another point highly in his favor for this lawsuit to be heard in Texas. Now he's asking for something that we don't come across too often except for in insurance cases. It's a declaratory judgment act. This is a federal statute. In the first update about the filings, we talked about summary judgment. And like summary judgment, this is a binding judgment. It's a decision made by the judge that has the same effect as an outcome of a full trial. The judge's decision is final. But just like a jury decision, it is appealable. But this act helps hurry things along. Instead of waiting the time that it would take to put together a jury trial, this decision can be made more quickly by the judge. You don't have to wait for the other party to complete a lawsuit, none of those things. Now, by way of reasoning that because of these allegations, these 10 different causes of actions in her complaint, that it caused great harm to his business, that he's losing business, because this was reported around the world without factual support, even though she's now belatedly attempting to obtain that. And he points out that the court has the authority to grant relief by this repeating again, he didn't breach a contract, he didn't engage in harassment or retaliation, and he goes through the list of the accusations. His second cause of action is defamation. He says that her accusations falsely stated that he had engaged in 10 illegal acts. And he says that these were provided by her or her agents to third parties, including media outlets, and that she knew or should have reasonably anticipated, indeed she hoped, that these allegations would be republished around the world. Now, there's an important qualifier here. If you're a private figure suing for defamation, you only have to prove that these accusations were made negligently. If you're a public figure, you have to prove that they were made with actual malice. But because he's suing for over the amount of $1 million, even though he's a private individual, he also has to prove actual malice. And when you think about him suing above $1 million, it's not excessive. His business is crisis management. If she put out all these allegations that he broke all these laws, that he sued for his actions, who's going to want to hire such a company? His business is potentially ruined by these accusations. Any kind of PR or crisis management under his company would now be tainted because of these accusations. So indeed, business lost could very well go above $1 million. And so that's how he comes to punitive damages in an amount of not less than $6 million. So to prove this actual malice, all he has to prove is that Blake either knew the allegations were false at the time that she made them, or that she acted in reckless disregard of the truth, meaning she had a high degree of awareness of falsity and in fact entertained serious doubt about their truth. He states that she knew and knows that they were not the harassers, retaliators, but she made these allegations anyway and leaked them to the press, hoping they would be widely republished, and they were, and then excluded him from the formal lawsuit, knowing that he had nothing to do with those events. So he demands a jury, but respectfully requests this final declaratory judgment, and that he be awarded damages for loss of reputation. So if he can't get this declaratory judgment, he demands a jury. And that was filed on February the 4th. And he attached the complaint. But for the sake of time, we're going to cover that in a different episode. So document 70, as I said, once one side files a motion to request something, then the other side gives a reply, then the judge decides, and that's what we have as document 70. The motion is granted. These that I filled in with gray are ones that are sealed and are not available for the public. So our next document is number 69, and it's an exemption from mediation and discovery protocols. Now, when we covered the last set of documents, we went through the scheduling order, and we talked about how there's specific protocols that are set up for time periods that you have to do certain things. And like we've seen with these motions, there's dates that responses have to be filed by. These things are standardized by case types. So there's a mention of discovery protocols, and we see that since 2015, these protocols have been put into place, and each case follows these protocols, and this outlines them. Not only that, there's mediation protocols, often referred to as alternative dispute resolution, or ADR. So it's an attempt to settle the case without it going to trial. There are court-appointed mediators whose job it is to sit down with both sides and try to come up with some kind of resolution, some kind of settlement, to resolve the case without a lengthy and expensive trial. There are cases where you can become exempt from these protocols, but you have to file for it. And so that's what this document number 69 is. They're saying that these protocols are inappropriate for this case. For one, they say at the conference that was held on January 30th that it was decided by everyone that settlement discussions at that point would be premature. Another reason for exemption is that the discovery schedule has already been entered, and that's what we went through in that scheduling order. They also mention that Blake's about to file her amended complaint very soon, and that the parties are preparing motions to dismiss. And so because of all of these circumstances, that these protocols and mediation won't work out because the discovery protocols are unnecessary since they have their schedule, and the mediation is premature at this point. And so document 70 is the court granting that, and that becomes an order. There is no 71 at this point, so our next document is 72, and that is a notice of appearance Attorney Catherine Bolger will be representing the New York Times. Document 73, in the last update, we see that a summons for the New York Times was approved, and this is the affidavit of service of that summons. Document 74 is a disclosure statement. When a business is being sued in federal court, there's a rule in place that they have to certify that they're not under a parent company or that no publicly held corporation owns 10% or more of its stock. So this is the disclosure from the New York Times stating that they have no parent company and that there is no one that holds more than 10% of its stock. And even if you do have a parent company, it's considered an extraordinary remedy to include that parent company in a lawsuit. That's one of the protections of parent companies. Having subsidiary companies, it does protect them a little bit, but still this information must be disclosed. 75 is really interesting because here we find out that subpoenas have been sent to AT&T, Verizon, and T-Mobile. This was sent out by Blake's team, and they're wanting phone records that go all the way back to December 1st of 2022, including but not limited to call logs, text logs, data logs, and cell site location information. And they say it's hard to overstate how broad, invasive, and atypical these subpoenas truly are. This is a civil litigation, not a criminal prosecution. And they're spicy again, and the lively parties are not the FBI. And because they're asking for the whole thing, this would include phone calls to doctors, phone calls to attorneys, phone calls to spouses. All of these things are privileged. They also state that it's wildly disproportionate and invades the privacy of untold numbers of third parties, including family, friends, business partners, and literally any other person with whom they've communicated with over a period of years. And that's so true. Any phone call, any text to anyone? Since December 1st of 2022, it's crazy. And this is another one of those situations where it feels like this is Ryan and Blake calling the shots and making their lawyers ask for these things, because it's just insane that seasoned attorneys would even make a request like this. And they say the lively parties, highly experienced counsel are surely well aware that the subpoenas they issued grossly exceed the scope of permissible discovery. And they list the federal rule that discovery is limited to any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. This is simply not. And they state that these subpoenas were leaked, along with a lengthy and combative statement. And so this is a media ploy, which, to be fair, both sides have played that now. It started with the New York Times article, but it certainly didn't stay there. And they say that they're not concerned about the public statement, but call it hypocritical, because public statements are exactly why Blake is suing these people. And yet they're turning around and doing it too. Wayfair says that they're using these tools themselves, but in a far narrower and legally permissible fashion. But what Wayfair says they're afraid of is that this is intimidating third parties and providing information that's far beyond what's appropriate. Again, listing spousal communications, medical information, attorney-client communications. And why do they want this location information? They call it a flagrant abuse of discovery, and that if it's allowed to stand, it would set a precedent that they're confident that the lively parties counsel will not be prepared to accept when it comes to the scope of discovery into their own clients' private information and communication. So they're saying, you're going to refuse this if we ask for it from you. Why are you asking us? And they asked the court to resolve this, saying it's highly time sensitive because some of the providers have already indicated that they will comply. So they're trying to stop this before it's out. 76 through 78 are simply referred to as redacted documents, and they're sealed so we can't see them. And that brings us to the last three we have for this update. There are three identical documents until you get to the last page. These are Blake's list of subpoenas. Now, it's interesting that these fall after what traditionally is called a motion to quash, and that's the document where they're trying to stop these subpoenas, saying they're overbroad and invasive. Because as we saw, some of these phone companies have already said that they're willing to comply. So document 79, the last page is the important part. This is what they're asking for. It's request for production. And if you saw my first update about the legal documents, we went through the phases of discovery. And in that second phase, we had document production. So that's the phase they're in now, and they're requesting these documents for production. So when it comes to Justin, this is where they're asking for call logs, text logs, data logs, and this location information, all the way back to December 1st, 2022. And if you think about this, filming hadn't even begun yet. Why would they want something this far back? Imagine handing over years' worth of everything on your phone to exploitive people like this. For Jamie Heath, the CEO of Wayfair, same thing. And the cell site location just really crazy to me. What are they after with that? That is very invasive. The third one is Melissa Nathan, and she's one of the crisis management people. Now for hers, they're asking for a much shorter time, beginning July 1st of 2024. But they want all the same, including her location. And then we have Malika Tuskovic, all of the same information, and going back to December 1st, 2022, just like Justin and Jamie. In case you don't know, Malika is the Vice President of Operations at Wayfair Studios. And then we have Jed Wallace, whose documents we just went through. And oddly enough, his is dated all the way back to December 1st of 2022, although it seems he was hired much later when there became a crisis. Document 80 asks all the same for Steve Sarowitz. Steve is the financier and the co-founder of Wayfair. And he's the one they accuse of making threats against Blake. He's the same as Justin, Jamie, and Malika. They want everything going back to December 1st, 2022. And Matthew Gibson, the same. So far, I've not been able to figure out who Matthew Gibson is, but they want the same information from him for the same length of time. Request for production number 3 is for Jerice Blackmon, and I'm not sure I'm pronouncing that correctly, but Blackmon is listed as an executive assistant in Wayfair. Number 4 doesn't point out to any specific person. It just says all documents and communications produced in connection with any subpoena in any action, related action, or consolidated action. And the final document, 81, mentions Justin again, same time period, same things. Jennifer Abel, we know that this is his PR person who formerly worked for Stephanie Jones at JonesWorks. They're asking for her things also from back to December 1st, 2022. Then we have Katie Case, from July 1st, 2024, just like Melissa Nathan, and she's the senior director of the agency group, which is Melissa Nathan's group. The next one is the executive vice president, also from the agency group, Brianna Butler-Coslow, the same time period from July 1st, 2024. And then this one is interesting, production number 5. Matthew Mitchell works for JonesWorks. That's the company owned by Stephanie Jones. Stephanie Jones is the person believed to have leaked the information from Jennifer Abel's phone to Team Blake. She hasn't been subpoenaed at all. She's not being sued at all, even though she was the original PR person for Justin Baldoni and Wayfair. But Matthew Mitchell, who is affiliated with JonesWorks, as we can see from his LinkedIn, is being subpoenaed all the way back to December 1st, 2022. So it does really look like somehow Stephanie is cooperating and being rewarded by not being sued or subpoenaed. Another employee of JonesWorks, Henry Hargitay. Again, not sure if I slaughtered that name or not, but his LinkedIn shows him to be the senior social media manager at JonesWorks. So that's 2 employees of JonesWorks, yet not the owner, Stephanie Jones. They want the same from him going back to December 1st, 2022. And then we have Tara Hanks, also going back to December 1st, 2022, and she's listed as the president of Wayfair when Jamie Heath was promoted to the CEO position. And then number 8, all documents and communications produced in connection with any subpoena in any action, related action, or consolidated action. So these are all things we would expect them to ask for, just not for the time period they're asking for, and it's way overbroad. And that's the last document that was filed. We're on weekend now, but I would expect the court to rule on this probably on Monday because there is some urgency to this if the phone companies are already getting this information together and complying with these subpoenas. Because once this stuff is delivered, you can't unring that bell. So that brings us to the end of this update. And if anything is filed on Monday, I will put that together for you as quickly as I can. Till then, this is Cassidy O'Connell saying stay well and stay tuned.